Welcome back. Sorry for the folks that are still having a break because you're going to miss the amazing content I'm about to present about. So thanks again for being here. I'm going to talk real briefly about just a few things that are important when you're drafting IEPs. You all have much more experience in terms of the specifics that you get into for kids, but I think some of these broad principles are important to keep in mind, particularly as you have repeatable things with similar kids to make sure you're kind of still going through some of the principles as you draft them. And also wanted to talk a little bit about the role that behavior intervention plans can play, obviously in IEPs, but also for district's liability when you go to due process hearings. So the first thing is that your IEPs have to have measurable annual goals, right? The IEP regulations require that those are appropriate to the academic advancement for the students. And I think that those regulations, which existed before, are even more important in light of the Andrew F. decision, right? The goals for your students need to be appropriately ambitious given the student's disability and their academic level of achievement to date. So this first case is an example where district was criticized because the student was reading at a first grade level, but the IEP reading goal was based on the state standard for ninth grade, right? It didn't really differentiate between what the goal would be for a gen ed student and what was appropriate for this student. So while it might be aspirational to have that student reading at the ninth grade level by the end of the year, it was inappropriate in light of what the annual goal should have been for that student. The other thing is that, and I think sometimes all of us are guilty of this with our familiarity with both the law and the educational area, but you need to make sure that the goal is such that a stranger would understand what that meant, right? So that the parents can see, are we making goals, are we not? If it uses so much acronyms and such convoluted research that it's not obvious to somebody that's not totally familiar and expert in the area, that may be insufficient. You also want to make sure that the progress measures and the reports in the IEP are specific so that you can measure whether progress is being made. Now, that's not required to use standardized tests to do that. You can develop those for your specific students. There's a preference in the regulations for peer reviewed research if that's practicable, but it doesn't have to be a standardized test. And you also want to show that goal can be measured, right? And so vague goals like for increases or improvement or gaining knowledge in, right? If there's no way for you to 3 or 6 or 9 months in to go back and revisit that benchmark and say, is that being met? Is it not being met, right? Then it's probably not an appropriate goal, even though everybody might agree that that's an aspirational goal. It doesn't give you kind of the incremental analysis to see, are we making progress? Are we not? What does the data tell you about how our IEP is being implemented? Other thing I want to talk about is transportation as a related service. So the federal regulations require the IEP to determine if transportation needs to be provided in order for the child to receive a free, appropriate public education. And so if the child's ability to access special education and to make academic progress in the general curriculum and with the special education requires transportation for them to be there, then the IEP team must make that determination. If it's needed, then you need to grant that. And then the other thing you have to look at is if there are some supports or modifications that are needed in order for that child to be transported, right? So not just generically, we can send a bus there to the house to get into the school, but we need a bus and it needs to have this type of lift or this type of tie down or this type of safety aspect or this type of personnel to load and offload the child, then you need to determine if that's required as well. And the child must receive that necessary transportation, including those supports, modification, and access at no cost to the parents. This is a more specific part of the Nebraska law that applies to the school's obligation to provide certain services to children with disabilities. The first, that sub A part talks about children who are forced to leave the district temporarily because a lack of educational services exists within that district. So the example would be a student is attending Al Smith Elementary within a district, but that whole district doesn't have the program that that student needs, right? If there's transportation is required to take the student out of that district to another location, the school is obligated to pay for those transportation expenses. Now, note, it's expenses. It may be logistically easier for you to actually take care of the transportation, but you're not necessarily required to actually do the transporting as much as bear the burden of those expenses if the parents are going to do it. And then the other component is that even if it's within the district, again, student goes to Al Smith Elementary, but he or she can't get the services he needs at that school. He needs to be transported, not outside the district, but to a different location within the district. the cost of the transportation between what would otherwise be the child's home school and the location where they're receiving those special education services, the district's also on the hook for that. And then there's also some specifics for bringing teachers out to homebound children if they can't come into school because of their disability, or if there's correspondence instruction that's approved by the commissioner. All of those expenses the district's responsible for paying to ensure that the student gets a FAPE. So let's talk a little bit about behavior intervention plans. Obviously, this is a plan for intervening with a student's bad behavior. You know, in theory, it doesn't have to be freestanding. I think in theory, we're saying it can be. In a second, we're going to talk about a lot of cases where the effects and the execution of the behavior plan were so critical to the IEP that the fact that they weren't part of one, I think, was problematic in those cases. But in theory, you can have a standalone behavior plan. You're not necessarily required to conduct a functional behavior analysis unless you're proposing to discipline a student. But that FBA can give the IEP team tools to create a BIP, right? So again, we talk about data collection. Let's make data-based decisions. If you do an FBA, it may better inform whether or not, you know, the first 4 things you're going to do in the event of severe behavior are likely to be successful or not, right? Might make that more efficient. And then whatever you do, you want to make sure you document the plan. You want to document the parent's agreement and or input into the plan. I certainly think that's true with the IEP, but that's going to be necessarily included in the procedural rights that parents have as part of the IEP. I think the parent's participation in agreement is even more critical if it's a freestanding BIP. And then you also want to document implementation of the plan, right? Are you doing what you said you're going to do as you go throughout the year? We'll talk, there's be some cases and examples of that. This first case is a case out of the 8th Circuit, which is the Federal Appellate Circuit, in which Nebraska is located. And so this is more binding than some of the other persuasive cases that we see. This is a 12-year-old Asperger's student. He was prone to inappropriate behavior, which when it was unmanaged, it largely prevented him from interacting with peers in an acceptable manner. Now, this student had actually entered into a settle agreement between the parents and the school that led to an IEP with placement in a self-contained classroom except for music class, right? There was biweekly IEP meetings to discuss further mainstreaming the student with his peers and his cadre. The IEP stated that there were attached behavior plans, but these only included short-term goals and objectives. They did not provide specific interventions and strategies to manage the behavior problem. So the goals were appropriate, but they didn't say how they were going to get there, like a cookbook strategy, right? In terms of what are we going to do on a weekly basis, what services are we providing, what personnel are going to be there, what programs are we going to use to help the child be successful. The kid had a special ed teacher and a one-to-one aide, and they used several behavior interventions that were not analyzed or approved by the IEP team. They did not chart data that was helpful to developing the BIP until the spring. So I'll talk about those personnel's effort in a second. So throughout the course of the year, the student's behaviors intensified. They prevented him from being mainstream, and as the court said, quote, substantially interfere with his ability to learn. There was 3 challenging behaviors documented in August, 10 in September, and 394 by March, right? So it was getting worse and worse and worse. When the staff attempted to increase the work to the 5th grade level, the stress led to additional behavior problems. So this was interesting, right? The BIP was part of the IEP, and one of the things that the school was talking about maybe why they didn't stick to that with fidelity was the academic progress that the student made. But they actually found is that as the academic achievement got higher, the student got more stressed out, and it led to more behavior problems. And so they had to back off the academic expectations to remove the stress, to try and control his behavior. And then it ended up preventing success beyond the 3rd grade level, right? So the parents bring complaint, they win an administrative hearing, they go to district court. The 8th Circuit found there was no question that the school failed to meet the procedural requirements by not creating a BIP. The issue is whether the failure denied the student a free appropriate public education. So the school argued the kid's receiving some educational benefits. Again, I'd also point out here, the standard that they were talking about in this case was like some progress as opposed to an appropriately ambitious level of progress after N through F, okay? So even with the lower threshold, the school failed to meet it here. And the court said because the IEP did not appropriately address his behavior problem, the student couldn't get a free appropriate public education. So even if the school wanted to point to some academic progress, it wasn't the progress he could have achieved and should have achieved if the behavior interventions were part of the IEP. The court said that the legitimate attempts by the staff in untrained behavior intervention were insufficient to reduce the inappropriate behavior such that the student could be successful. There's a quote in there, which I think sometimes judges do. And usually if you're a lawyer with one of these, you know you're about to lose when they kind of throw some gratuitous compliments at you. But the court did say, although the para and the special education teacher were commendable in the fact that they were trying to help the student, the fact of the matter was that they didn't have the training or the expertise to develop the behavior intervention components to make the IEP successful. And so those efforts were great, but as a legal matter, the school still failed to provide a FAPE. Yeah, this is just another quote that talks about the court's conclusion. So I'll talk real briefly about the Tuolumne case. Jordan's going to talk about it in a second. This is a 5th grade student with an IEP for ED and SLD. He served in specialized behavior program, and the family in the case was seeking a residential placement. So the takeaway of this case was that this student was exhibiting really severe behavior, like hitting a teacher with a fire extinguisher, throwing rocks at peers. I mean, elopement that actually happened such that the student was placed in a psychiatric hospitalization situation. But what the school did is they took a boilerplate behavior plan, and that's what they gave to the student, notwithstanding the severe behavior. So the district was dinged because they really didn't, again, we'll talk about this throughout today, they didn't use the I in the IEP. You know, you need to have an individualized component to the behavior aspects of the IEP as well. If you take a boilerplate thing that's supposed to be for, you know, kids that run the gamut, and you apply it to a kid that has really severe behavior problems, it's going to be problematic from a legal standpoint. This Hawaii case, this was an 18-year-old student with ASD, had a low IQ, and ROHAD had significant behavior and aggression. The IEP staff said it will follow the behavioral support plan daily. The behavioral support plan was not in accordance with the IEP. It was never provided to the parent, and the parent sued after a conflict about the placement and the services. The district took the position that the BSP was not required to be incorporated into the IEP, and the court said because it was not part of the IEP, the district was free to amend or curtail it without the parent's knowledge or input, which seriously infringes upon her right to participate in the IEP process. So in this case, the parents needed to be able to see that plan to know what services were being offered to the student. And just having generic behavior goals and supports in the IEP were also insufficient. So in this case, for example, it had a thing like, we're gonna have weekly behavior analysis, and we're gonna make improvements in behavior. Those were the goals. And then it generically said there was gonna be like 405 minutes of counseling for that semester. But it didn't talk about, we talked about before about the appropriate and the granularity with the academic goals. The same thing needs to be true for the behavior support plan, right? So the fact that they had those vague goals on there was like having no goals at all from the court standpoint. This is a case out of Alabama. This is a 17-year-old student with disabilities related to reading and communication, and had emotional behavior issues. In August 2005, the student had an outburst in the luncheon, ended up throwing food. A week later, he caused disturbance and cursed in the cafeteria. 2 days later, received an out-of-school suspension for calling a teacher a, quote, freaking idiot, which is pretty tame in KSB standards in terms of language. By the end of August, the parent's lawyer complained that the district didn't have an appropriate BIP in place for the student. So in September, they met to develop an IEP and a BIP. They agreed to a system where a student received points and ultimately rewards for refraining in physical or verbal aggression. The student would receive escalating levels of in-school suspensions and also write an essay for each incident of aggression, and that those would increase with each subsequent misconduct. The student was to receive support from a behavior support individual. That was not implemented. The student was also supposed to receive counseling. And then after the meeting, this again, when you're amending the contents of an IEP, the fact that it hasn't, that substance of that has not taken place in the IEP, when the plan was finalized, the parents signed off on, that should always be a red flag that it's going to be a problem. So after the meeting, the SPED director added a sentence to the BIP stating that the student handbook would govern more serious conduct. Okay. The student continued to engage in misconduct, but the school responded inconsistently with the punishment. So there was disruption, there was a dress code violation, there was disrespect to teacher, kids shouted in the lunchroom, there was generalized threats, and the school inconsistently applied for the rewards. Sometimes they applied them, sometimes they didn't. It inconsistently provided support, failed to provide documentation of a lot of the supports it was giving, failed to provide the counseling that it was required. It ultimately culminated in an incident where the student disrupted class with a peer, threatened the teacher, and refused to follow redirection. A referral to law enforcement was made, and it led to the student being adjudicated in juvenile court. which ordered the parent to disenroll the student from the school and not place the school in any school in the district. The hearing officer found that the school district did deny the student FAPE with its implementation failures. The district's actions and omissions obstructed the success of the student. The director recognized that students with behavior problems have to be handled very systematically, and in that structure, they fashioned a specific behavior management program to work, but the school completely failed to carry it out, right? So they didn't always respond with the student discipline consequences that they said they were going to. They didn't provide the sort of supports they said they were going to. They didn't provide the guidance counseling that they said they were going to. So the takeaway here, it sounds simple, but obviously we talked before about the importance of having those components and details in the IEP related to behavior. The takeaway from this case is if you have them in there, do it. And if you don't do it, it's going to look bad from the court standpoint. All right.
All right. I know you're all thinking, wow, when did Bobby go on a diet and get so good looking? Hate to tell you, I'm Jordan. I'm the new guy if you haven't met me yet.
Jordan is the tallest KSB lawyer by about 6 inches, so in fairness.
So we're going to kind of roll through some of the big points on developing your BIPs. The biggest thing we can stress throughout this entire section is one thing that the Andrew F. Court, which I'm sure you've heard about in all of our presentations you've seen over the past year and a half or two, really focused when they talked about the standard of FAPE needing to give appropriate educational benefit. The big deal is that it's individualized. And the dispute in Andrew F., interesting enough, was really about the behavior supports, interventions, the behavior sections of Andrew's IEP, which were largely what the parents had requested be put in the IEP. So when we start out, we'll see in CF, we have a student with autism that has significant maladaptive and significant interfering behaviors. Parents wanted a one-to-one program. School said, no, that's not necessary. We're going to put in a 6-to-1 program with an aide. So the parents unilaterally placed the student in a one-to-one program and sought reimbursement. School's eyes get big, it's getting expensive, so they proposed a new IEP, and again, they only gave minimal consideration of that one-to-one placement. And the BIP that was in the IEP simply listed behaviors and strategies that were vague and not specific, and they weren't tied to the student's behavior in the data. Now, what's interesting, and what Cody mentioned earlier, is that FBAs, functional behavior analyses, are not required in the BIP process. But you'll see in this case, the Second Circuit noted that the omission of the FBA in drafting the BIP invites the court to increase their scrutiny of the subsequent BIP. Now, in this case, the school came up again with kind of a boilerplate BIP that really just incorporated some of the ABS, ABA type services. And the failure to conduct the FBA, while it isn't legally inadequate as a result, after that, the district wasn't able to show that they relied on adequate data. So they were again failing to do enough steps in between to show that this was an individualized plan tailored to the student's specific needs. So when you're developing these BIPs, you need to focus on the individual student's behaviors, and it should be any behaviors that interfere with the important teaching and learning activities of the school. So in one case we have with Ingram Independent School District, there's a kid that napped all the time in class. That might not, out of sorts, trigger your idea that you need to create a BIP for the student, because a lot of times we think of the disruptive, violent behaviors as those that really trigger the requirement for a BIP. But in that case, just napping in class. In another case, a 5-year-old with autism required a BIP because they were self-stimulating all through class. They would inappropriately vocalize at different times, and it made it really hard for the student to focus when they were worried about their own body, when they were focused on shouting things out. It interfered with the important teaching and learning activities of the school, and so a BIP was required. Now, when you get into pairs, you start to see again these form BIPs or these copy and paste from the ABA standards just aren't cutting it. So a student with autism was enrolled after an extended period outside of public education. The school develops an IEP without collecting their own evaluative data, and the court says they were presumably informed by the parents' own assessments that were provided. School puts the student on a shortened day to start. About a month later, parents are complaining that this is an appropriate placement for the child, and so the school seeks additional data to revise the BIP, and they have a specialist observe the student in class 5 times. But the specialist takes the data from that 5 observational periods, so in this case they do kind of that FBA step, but then the result is a BIP that just lumps all of the student's behavior into a single category of non-compliance. Eventually, the school moves the student to a more restrictive placement that apparently doesn't meet any of the accreditation criteria of the SEA. So, not surprisingly, the mother disagrees with the placement and files due process. Mother wins in front of a hearing office, school district appeals, they wanted to pay more attorney's fees. The behavior plans developed for 2013, 2014 were deficient because they lumped all of the behaviors into the category of non-compliance. The plan didn't show an understanding of the student's behavior or the causes. And it's that last portion there that really kind of jumps out. It's the causes. The entire point, the only required portions of your BIP are positive behavioral supports and interventions. It's difficult to support a student or to intervene in their behavior if you don't know what's causing it. Just like for a doctor, they don't treat symptoms, they treat the underlying conditions. So we go back to the Tulumni case that Cody kind of mentioned, and we look at what the court said there. The behavior goals that they had were not measurable. In the counseling setting, the student will demonstrate positive peer interactions, but that was subjective to the clinician. Student will independently seek help when engaged in difficult or non-preferred tasks. What's non-preferred? The student will calmly and effectively communicate his emotions and needs in 4 out of 5 trials. Now, the important thing here is that BIP that they created, not only did it have these pretty subjective and vague goals, but you'll notice what's missing is any supports or interventions. Now, the 8th Circuit has said your BIP doesn't need to require behavior goals. Your BIP needs to have all of the things that the school is going to do to intervene in the behavior and support the student. So the focus of the BIP should be as much on the student's individualized behaviors and the district's response rather than the student's response to their own behaviors.
So I'm just gonna hop in because I can't stop myself because you know how I am. Oh, here I am. So one of the things that I see over and over in BIPs is exactly the issue that Jordan is talking about here, where the BIP is more like a list of the stuff we want the student to do. Jordan will stop mocking Bobby. Bobby will stop kicking Jordan. Instead of articulating what our individualized intervention is going to be to help Jordan to stop mocking Bobby, or where we say, you know what, that isn't maladaptive behavior, so we're going to encourage Jordan to mock Bobby. But what I'm saying is that the BIP shouldn't be like a list of the stuff the kid needs to do.
That's your code of conduct.
That's right.
The BIP should never be your code of conduct. And in this case, the student will independently seek help when engaged in difficult or non-preferred tasks. That doesn't address the underlying cause behind why that student is exhibiting maladaptive behaviors when faced with difficult or non-preferred tasks.
Exactly right. And I thought the hearing officer in this case was kind of crappy to the school when he says, well, who says it's non-preferred? Because if I recall right, this kid was like kicking things when he was, I mean, it was pretty obvious. But I think that idea of we need to say Jordan will independently seek help when he's doing seat work, that would be better than saying in difficult and non-preferred tasks, so that we can articulate what is the difficult task. So I didn't mean to interrupt.
No, of course. And then your support that you tie to that behavior should be tied to the cause. Bobby has a difficult time remaining calm while in seated tasks, so we are going to give Bobby 5 minutes of walk around time after every 20 minutes of seated tasks. It needs to address and be directly tied and individualized to the underlying causes. And the big thing then is when you get a good BIP that identifies the triggers, if you will, of a student's behavior, you need to pay attention to those and follow those. So in this case, a student had a BIP, and the BIP specifically stated that first of all, the student was never to be touched by a male, and that police officers should only be called if the student's safety was in danger. The case is not entirely clear, but I think what is pretty clear is that the student had some type of trauma in her past, probably tied to the presence of a male figure. And whenever a male was introduced to a situation in which the student was misbehaving, she would escalate seriously. And the same was true if it was an authoritative presence like a police officer. The BIP also said that the student would be allowed to call her mother when she wanted through the day so that she could engage in some de-escalation that way. Well, kid's brought to school one morning. Mother drops her off, specifically tells the front office she's not feeling well today. If she needs to call, let me know. Student ends up in a bit of a tiff with her teacher, and she tries to leave the classroom so that she can go call her mom at the front office. The teacher refuses to let her go down to the office to call, says that if she wants to call, she could call from the classroom phone if she remembered her mom's phone number. And it's at that point where these behaviors start to escalate because we're not implementing the BIP and addressing the underlying causes. SRO physically struck the student after the SRO responds to the student trying to leave the classroom. Student escalates when she sees the SRO as the BIP contemplates, and things really get physical. The student ends up being thrown onto the ground of another room, repeatedly punched by an SRO while she was stuck on the floor, and then twice administered pepper spray. However, in this case, the parents were bringing it from a unique posture that kind of ties into the Fry case that you've probably heard about lately. They were arguing that because the SRO was called and because the BIP wasn't followed, they were discriminating against the student under the ADA. The court dismissed the claims against the school, not because the school did what was right, but because the court recognized that the problem here was that the school may have denied the student FAPE under the IDEA. And so the right avenue for the parents to address these issues was through the IDEA. And then we have another great case. The focus again is on the underlying.
Just for 2 seconds, I'm sorry. One of the things I wanted to just jump on with that SRO case, like the SRO handcuffing the kid, pepper spraying her, punching her, like not understanding that she has special needs. There's a new law on the books in Nebraska regarding SROs, and every school building with an SRO or every school administrator with an SRO in his or her building is going to have to do 20 hours of training before 1/1/2021. And every SRO is going to have to do 20 hours of training. And one of the things that we think that training should focus on is this exact issue about SROs and special ed kids. We're kicking around doing a special thing maybe this June where we have an administrator bring their SRO and they do it together, because there's a crap ton of these cases where the SRO ends up assaulting the special ed kid, and then both the cop and the school get sued for discrimination.
And really schools are kind of in a sticky situation in that case because that SRO didn't have that student's BIP to understand the problems with the behavior.
That's right.
If the school had given the SRO that student's BIP, they would have violated FERPA because in almost no situation will that SRO qualify as a school official to get the BIP. And unless there is a very serious event and there's time to react to it that the emergency exception would apply, the SRO probably isn't going to respond to that student. So the school was the first line of defense there in implementing that BIP, and all hell kind of broke loose when they failed to recognize the student's causes of the behavior and then follow the BIP. So that just goes back to, we need to be focused on the causes of the behavior. So in this case, a student had Prader-Willi syndrome. If you're not familiar with Prader-Willi, it's a genetic defect that causes students or children to have constant insatiable hunger. It also causes a lot of different intellectual disabilities that for a lot of students means they can't really understand or conceptualize time. They're often really impatient. And that also ties back into that insatiable hunger. They don't realize they ate 5 minutes ago. Time is essentially meaningless. So the parents were unhappy with the services that they were getting from the school district, and they tried to get a private placement for their student. The primary focal point of the case ended up being the behavioral support services that the school was giving. The educators would seek out the student and delay her by telling her, "I'll be with you in a minute," under the plan. Well, for a student whose impulsivity is tied to the fact that she can't understand time, telling her, "I'll be with you in a minute," means essentially nothing. And there were other things in the behavioral support plan where if she behaved well enough for long enough, well, then they would give her some food. But for a student that's constantly hungry, that's not really an appropriate incentive to use.
It's like when you're fighting.
Yeah.
And then, you know, essentially all of the plans and services and supports that they were going to implement, they were reactionary. None of them sought to stem off the student's behavior. It was when the student gets impulsive, we'll tell her, "Wait a minute." When the student finally behaves well, we'll give her a cookie. Well, the court said, well, the district and its employees did indeed proceed earnestly. Going back to what Cody mentioned, if you hear those words "while" and then a compliment, you're
That means
screwed.
you lose, yeah.
Yep. They did so in a manner inappropriate to the student's condition. So the staff were required to be trained on Prader-Willi. There was a required meeting with the parents to develop an appropriate DIP that actually addressed the causes of the student's behavior. But a private placement wasn't necessary because schools, you can do this. You can identify even the most complex underlying causes and you can address them appropriately. This case, a student with autism, the IEP proposed a 12-to-1 environment but didn't have a formal BIP. Parents said the student's placement's inappropriate and the IEP is inappropriate because it didn't include a BIP. However, the IEP did identify the student's behaviors that would impede his learning, provided techniques the teachers could employ to respond, and included related skills. So we've checked off all of our boxes. Remember, your BIP doesn't have to be a freestanding document developed in the IEP process. The BIP is the way that you meet the regulatory requirement of providing positive behavioral supports and interventions. And that's what the Second Circuit says. The IDEA requires that in developing the IEP, we identify problems that impede the child's learning, and then the district must consider the use of positive behavioral interventions and supports. Even without a formal BIP, if your IEP does this, it is sufficient. In this case, the Eighth Circuit ruled that you do not have to have behavior goals. And they go back to that same provision that the Second Circuit did. So the parents of this child said, look, the IEP identifies the problematic behaviors. It tells us what we're going to do and gives very specific strategies to address those behaviors, but there's nothing for the student to work on. And IEPs need goals, right? Eighth Circuit says no. IDE does not require an IEP to create specific goals with regard to behavior. Goals are not the focus. And this again goes back to what is required. We are not required to find ways for the student to help themselves. We're required to find ways to support the student's behaviors. The district's good faith effort to enable progress by stemming disruptive behaviors is evidenced by the training that they got, the services that they provided, and the sensory diet they put the student on. In this case, they did an FBA, they identified the behaviors, they did everything they needed to. Goals were not required.
So, sorry, just so you stack all these cases up side by side by side, here's the bottom line. There's no specific format that you have to use. There's no one size fits all solution, right? You can have a freestanding BIP, you can have freestanding goals, you can have it interwoven throughout the entire IEP. You have to address the behavior that interferes with the child's education, but there's not any specific way that you have to do it. So as your lawyer, we love that because we can look for multiple ways that you comply. As the educators implementing, you got to ask yourself, where is it? Somewhere, where is it that we are supporting the kids' behavior?
And kind of the final points as you're developing these BIPs is focus on where you're going to need to implement these supports. So you need to identify where these problem behaviors are occurring and you need to address them there. In this case, a student had problems with elopement. She would assault other people, yell, disturb people. The behaviors happen not only at school, but also on the bus ride home, which was part of her IEP as a related service, as Cody talked about earlier. So here the parents say in a complaint, the staff on the bus aren't even implementing the IEP and all they want to do is stick our child in a restrictive child safety seat. That's not going to allow her to access that part of her IEP appropriately when we're not implementing the BIP. And in this case, the Maryland State Education Agency said, yeah, you're right. If a service is part of the child's IEP and their behavior impedes their ability to access that service, the BIP should address those behaviors. And then finally, we have a student with autism who is much larger than his classmates and engaged in aggressive disruption and elopement and self-harm. This really culminated in an incident where the student escalated, finally was taken to a self-contained room, begins banging their head on the wall. Very scary situation. The sheriff responds after presenting to a different class in the building, handcuffs the student, tries to restrain the student from banging his head on the wall. So the school continued to implement and revise their BIP, and eventually they decide that they're going to need to put some restraint provisions in so that they can stop the student from harming himself. The mother said, no, 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 no. My student should never be restrained. Not even if he's hurting himself, not even if he's hurting others. District said, we're not going to put a BIP in place that's not appropriate. The school did the exact right thing here. They didn't capitulate to the parents' unreasonable request. They stuck to their guns and said that wouldn't be appropriate. So the mother said, well, if you're going to restrain him, I want to homeschool him. District said, yippee. The district agrees to let the student be homebound until they can further address his placement through IEP meetings. But later, the mother complains that while the student was homebounded, the school wasn't implementing the BIP. But because the homebound services were separate from those in the IEP, and the IEP never said that the student would receive these services in the home from the school, the BIP wasn't required to be implemented. And then once again, I want to tie things off with boilerplate is never okay, especially after Andrew F. You'll hear us say it time and time again, an IEP is not a form document. This means that a boilerplate BIP, even if it is specific to the student's disability, is not specific enough to that student. And the other thing that this case really highlights is something that Karen mentioned. This is not a code of conduct, and your BIP should not be how you determine the student's placement. Your BIP should support the student in their placement. The BIP should not be changing the placement as a reward for their good behavior on a daily basis. That deprives the parents of any certainty as to where their child's placement is going to be, and it deprives the parents of any ability to speak into and participate in the placement decision process. So what do we suggest for BIPs? Again, this is a plan for positive behavioral supports, not a code of conduct. So you need to review the possible menu of supports. There are all types of great resources, and the parents are going to bring them, I guarantee it, telling you this is what you should be doing. Consider those. Do not copy and paste all of those. That is what took Andrew F. School to the Supreme Court. How much money did they pay in fees in that case?
Well, the total settlement was
1.3 million in Andrew F. School, because they decided to do exactly what they thought was right, which was let the parents have the behavior program they want. Give it to them the way they say, put it in the IEP. Time in ISS can be an accommodation, but don't make it a change of placement. If the student needs to get some time away from peers to desensitize, to de-escalate, to bring their behaviors down, that can be an appropriate support. But don't change the student's placement to ISS every time they misbehave as part of a BIP. That if you have to do that, they're on the wrong spot on your continuum of placements. And it's time to change their placement, not use this BIP. And then, and when you're doing so, distinguish between seclusion and cool down. Another thing, because we are always looking for the underlying conditions and we're trying to positively support these behaviors, stop them from happening, you need to consult with your school psych or your ESU psychologist, because you need to be understanding what is causing these problem behaviors so that you can actually support them. A day at home to regain emotional control is placement. That's not a suspension. Don't use it as a suspension. Use it on your continuum and use it in your BIP, not as a change in placement, not a suspension, but as a way to positively support the student. Same idea as the ISS. Send the school psychologist to observe the student at home or in the community.
Sorry, I just have to chime in. When you have the parent that says, oh, we never have these problems at home, that's probably because the kid's playing Fortnite and eating Cheetos instead of doing math homework. So sending the psych to observe the kid at home, then you have an actual, certificated person saying, no, I collected data, and the reason he wasn't acting out is because there were no demands. I love sending the psych to watch the kid at church, at the bowling alley, at home, to gather that out-of-school data. Sorry.
To be fair though, Karen, Cheetos are delicious.
And Fortnite's awesome.
I don't know about Fortnite. I was born in the 70s. So we got a question. In regards to transportation, can you further provide clarification in regards to 014.01B2? This is an aspiring lawyer with citations like that. The nature of the child's disability is such that special education transportation is required. Does this mean students that require a wheelchair and are those that have such significant behaviors that they require special education transportation? Or does it mean for those that qualify as intellectually disabled? I feel that we're over generous on providing transportation, but I struggle to interpret that part of the document. The answer is yes, right? So in theory, it depends on the nature of the disability and what the IEP team determines as to whether that student needs transportation in order to receive the special ed such that they get FAPE, right? Now, admittedly, a student in a wheelchair that needs a ramp getting on or off a bus, or that parents don't have a vehicle to transportate them, that's probably more obvious, right? Than maybe someone that has an SLD or they're behind in reading or something else that you're providing supports that don't think it's a physical manifestation. It's tough to have the interplay of transportation, right? I'm sure Karen and Bobby can have better examples of where it might be an intellectual disability, but is whether it's manifesting itself in social interactions or something else, such that you do have to provide something specific in terms of either modifications or transportation. But the short answer is you don't get to say, it's not a physical disability, it's intellectual, so we don't have to provide transportation. I still think you need to look at that and document it and make the decision, make sure it's part of the IEP.
Yeah, and I just want to reinforce what Cody said. It's 100% a team decision. There's a couple cases out there where students with an intellectual disability were entitled to transportation because they couldn't make the bus transfers in New York City or navigate the subway system. But if what we're talking about is somebody, I'm from Crete, somebody walking from Code Avenue, which is where I grew up, the 6 blocks to the high school, somebody with a low IQ can understand that straight shot, walk 6 blocks this way. That student probably wouldn't need transportation, as opposed to a student with an intellectual disability that lives in the country and would have to have a school permit to drive to school, probably would need transportation. So it's team decision based on individual factors, which is, it's like, you know how in church during the children's message, the answer is always Jesus? In IEP questions, the answer is always, it's a team decision. You're never gonna go wrong saying it's a team. Last question we have before we're gonna take another short break. And Bill McAllister, I love you with a white hot love. You make my day. Bill says, I'm assuming that a certain percentage of our IEP should include BIPs. What is that percentage? The percentage of IEPs that should include BIPs is the percentage of students who have behavior issues. Now in West Point, where everyone is happy and nothing ever goes wrong, it's probably a really low percentage. And in Crete, where I grew up, it's probably a really high percentage. In Detroit, where Steve grew up, it's probably 50%. So Bill, the answer is there's not any set percentage. And Texas is in huge trouble right now because this Texas Department of Education had set like a percentage rate for what they thought special ed students should be. And the Federal Department of Education is freaked out, has a whole bunch of compliance going on for Texas. So I would really urge you not to think about this in terms of a percentage, but think of it in terms of each individual kid we should be looking at. Do they need behavior supports or not? Okay, so I told you we were all highly caffeinated, so we've been drinking coffee all morning. We need a break to access the restroom and take a deep breath. So it's 10:57. We will reconvene at 11:05.